For more on the China-U.S. trade relationship and the growing importance of protecting intellectual property rights, we are joined by Lei Mei, managing partner of Mark and May. A lot of M's there. Thank you very much, and welcome to Biz Asia America. Look, this is a very big topic, although a lot of times the retail person doesn't necessarily hear so much about it because the details are all in court or on paper with folks like you. But help us better understand the definition of intellectual property rights. Daniel Wrench has tried to explain a little bit, but that definition has changed over the years, has it not?
Right. Traditionally, intellectual property rights involve patents, copyrights, trademarks. But in recent years, we have seen a lot of trade secrets issues involving allegations of leakage of U.S. companies' trade secrets to China, which may or may not be true, but we have seen a number of cases coming up.
So, for example, if I invent this pen, I mean, that it would be a patent. Is that correct?
Potentially could be.
But if I had plans to design a new pen, that could be a trade secret, is what you're saying.
Right.
Okay. The rise of IP cases, certainly over the last decade, a decade ago, no one would know what we're talking about.
Right.
But fast forward to today, I mean, this is the talk of the business community, especially when it comes to trading between the United States and China. Help us get a better gauge of the knowledge base between both the U.S. companies and also the Chinese companies as well, and perhaps the rise of all these cases.
Right. So in our experience, I mean, we've been monitoring U.S.-China-related trade issues in the area of intellectual property for last many years. Essentially, for the last 10 years, more than 40% of U.S. International Trade Commission cases involving IP issues had Chinese companies in the case. So that's large. We are talking about 40% here. So that's a large number of Chinese companies being sued in the U.S. I think partly that's because of the increased trade between the U.S. and China.
Well, there's more business.
Right, it's more business. When Chinese companies are doing better in terms of market shares in the U.S., the U.S. competitors sometimes use IP as a business measure, try to gain back market share in the U.S.
Let's talk about, because you're saying something here between the lines as I'm reading it. For a lot of Chinese companies, they come to the United States to do business, and on one hand, they want to follow the rule. They want to do things correctly. But on the other hand, there's a little bit of intimidation factor because as you're doing business, you don't know who owns the rights to certain things sometimes. Is that when you and your firm step in to help them? Is that?
Right. So when I started my firm, and we recognized there's a niche in the marketplace because a lot of Chinese companies, when they come to the U.S., they have no idea about U.S. legal market or legal environment. So when they get sued for IP infringement, typically they end up paying millions of dollars in attorney fees to fight those allegations. But for the medium-sized Chinese companies, sometimes that's not an option. They don't have that amount of money to pay lawyers. So when we realized we could step in to create a smaller firm that provide excellent service, but at a lower legal budget for our clients. And we recognized that there's a need for that. So when I started the firm in 2009, and it turns out that was a correct prediction. We have grown very quickly since.
Help us better understand the landscape now going forward the next couple of years. This issue is not going to go away anytime soon. So for companies, both in the United States and China, is it possible that these cases can avoid getting lawyers? I know it doesn't benefit you, but is it possible they could perhaps better understand the issues and talk with each other and negotiate deals without the lawyers, or do you think that that's premature?
I think there is, even now, I mean, there is a trend for companies to avoid going through a lawsuit to address the trade disputes. So, and also in the big environment wise, when the Chinese government really pushed really hard for IP protection. So a lot of Chinese companies now, they actually, before they start selling products to the US, they consult with attorneys like us to assess the potential legal risks and redesign their products in a way that has less infringement risks. So in the future, I think there will be, hopefully there will be less and less lawsuits, but with increase of the trade,
I've heard this before from a lot of companies, and not just Chinese companies, but companies from around the world who do business in the United States. And one of the frustrating aspects, and it may go for Americans too, but the legal environment in the U.S. is very litigious. we can sue each other for almost anything.
Right.
And a lot of companies are intimidated by that. And so my question is what advice do you give companies who are interested in doing business in this kind of environment? I mean, they want to come and make money,
Right.
but they're scared to death of being sued for something they may or may not have done that's wrong. What do you tell them?
Yeah, my first recommendation would be always plan ahead of time, right? To assess potential legal risks when they do a product development. Definitely need to assess other people's patents to see whether they potentially infringe people's patents or not. If there is a real issue infringement, they really need to redesign the product so that there's less chance for them to infringe other people's patents.
I guess it's there's no simple answer, but I suppose companies like yours can help some of these folks.
Right.
All right, Lei Mei, thank you very much. Of Mei and Mark, thank you again for your time.